on issues that relate to surface rail transport as part of the Interstate Commerce Clause, basically saying that even rail systems that are completely intrastate within a single state, if they tie into interstate, are subject to regulation by the federal scheme that's established by the Act. So the Surface Transportation Board, which was created under this, reviewed the high-speed rail project and declared that it had jurisdiction over it, and therefore the State Attorney General filed a sort of late-breaking brief in the Court of Appeals saying, oh, never mind, you don't have jurisdiction. The feds have asserted jurisdiction here. NEPA controls. We don't apply the California Environmental Quality Act. And so Court of Appeals, at this late date, please dismiss the case, and we'll just proceed under federal review. Understandably, the appellants did not like this approach, and Town of Atherton is filing a brief opposing that on a number of grounds, some of them substantive and some of them procedural. And the procedural arguments are essentially that it's too late to raise this argument. It is not of the kind of legal argument which, or that is legal decision, the way, say, a court decision would be, that would warrant dismissing a case on appeal for lack of jurisdiction, et cetera. There is some coordination by other interested entities to file an amicus brief. An amicus brief, again, is a friend of the court brief, which would further elaborate these arguments on the question of federal preemption and whether CEQA would apply to the high-speed rail project, and therefore that there was still remedy to be had in the case that's pending in the Court of Appeals. So the lead amicus brief has been authored on behalf of the Citizens for California High-Speed Rail Accountability, which is a public interest group. And Kings County is attempting to join in that amicus brief that is to be filed tomorrow. The council was made aware of this issue and considered it fully. Because of the tight time frames, there has been an inability to do a thorough review of the proposed amicus brief. It was made available to the city today at 4:30 p.m. It's approximately 50 pages long. So the council has not had an opportunity to review it in detail, though they have had an opportunity to consider the macro issues, if you will, about joining in as amicus. In order to join the amicus brief, even though we would not be writing our own unique amicus brief, we would nonetheless have to make application to the court. And the court has discretion about whether to allow an entity to participate as amicus. And traditionally, the way that it makes that decision is to look at whether the proposed amicus either has some kind of unique expertise that's not represented by the parties to the case, or is affected in the way that the parties to the case are not. In other words, is there something that the amicus could bring to the table that isn't already represented by the litigants to the case? So an application made by the city of Burlingame to join in the amicus brief would have to make the case to the Court of Appeals that they should hear us on this subject and what our sort of unique standing is, or other things that we can bring to the table that aren't currently represented in the case. So the council has discussed some of these issues in closed session with me as their attorney. This is a decision analogous to whether to initiate litigation and is therefore appropriate for closed session discussion. However, the council and staff wanted to have an open session item for the vote on this because of the public interest in this topic.
Thank you. Any questions?
Can I just ask one point of clarification? I think we made a financial contribution to the lawsuit Toes et al. Did we also do it for Atherton?
No. Oh, I'm sorry, I was mistaken in that. I wasn't here at the time, but yeah.
I don't think we did.
I apologize.
No.
That's okay.
Yeah. Any other questions? Okay, if not, I will open up public comments. I do have a few blue cards. Can I have Pat Jorney, followed by Charles Volz, and then Ted Crocker.
Good evening once again on this issue. Pat Journey, 1445 Balboa. First of all, I want to thank the mayor for taking this issue and putting it in regular session on this agenda rather than having it in closed session, because I think it's a very important topic. As I said to the closed session this evening, I know that we've been hesitant to join litigation for a number of reasons over the last few years, but with our contribution of $5,000 to Toast et al., we have sort of tossed our hat in the ring saying what we're kind of for without actually filing papers. And I know that we got the news that Jerry Hill's bill passed through legislation last week, but I don't think that anybody thoroughly understands that his bill will not guarantee a third rail, the stopping of a third rail, a passing rail, which is going to be necessary for either high-speed rail or electrification, two separate but co-joined projects, and that it's easy to put that third rail into the legislation right now simply as an amendment to the bill when the authority or the state decides they need that third track. Second of all, there's absolutely no guarantee that we won't end up with aerial tracks and aerial structure. In fact, we might end up with grade closures. As you know, we now have 6 at-grade crossings. Only 2, in my opinion, are guaranteed to remain open. Those are the ones going to the freeway. That would be the Broadway, for which we've just pledged ourselves to undertake a study, and for the peninsula, because that's the only other way onto the freeway. But that leaves the other crossings, Howard, Bayswater, North Lane, and Morrell, which nobody ever thinks about, as possibly being closed to traffic if there's no grade separation. And I want to remind you that, I forget if it was called East Lane or South Lane, with the expansion of the new station, I don't care what they said, we've lost it. We're never getting that back, because whatever is done, that's gone. So we've already lost 1 grade crossing. By accepting Hill as a done deal, we're undercutting our support of the Taos action. So I think that we ought to reconsider that Hill's bill is not a done deal. But more importantly, I want to say that there is no EIR for either electrification or the programmed EIR. And if the Attorney General prevails, we're going to end up with NEPA rather than SEPA protections going through the middle of our town, and I think that's unacceptable. So please, join the Amicus, which I keep calling Animus. Thank you.
Thank you. Charles, followed by Ted Crocker, and then, sorry, I missed Russ Cohen.
Charles Volt, 725 Vernon Way. Good evening, Madam Mayor and council members. An important reason that the City Council should make a strong, unequivocal opposition to the preemption of CEQA is that it appears that the rest of the peninsula has been lulled to sleep on high-speed rail over the last several months. The apparent reason for this is twofold. One is the belief that the High-Speed Rail Authority has adopted the blended system and all is well. The alternate reason is that the Jerry Hill bill effectively limits the peninsula high-speed rail to a 2-track system. Would that these were true, but they're not. At best, they're half-truths. Let me address them one by one. Before I do that, the worst part of it is it creates the illusion that the problem is solved and we can just go to sleep with everybody else. The High-Speed Rail Authority has never abandoned its position that it's entitled to go full bore 4 tracks down the peninsula. It's in their program level EIR We tried to get them to change it. They stuck to their guns. They said, well, we may need to change it, although our present intention is just to use the blended system. They never define what the blended system is. It's primarily 2 tracks. It's going to be mainly within the right-of-way. There's going to be additional tracks. And by the way, you can get 3, 4 tracks between the Millbrae station and the Burlingame station, by and large. So that we have that possibility in front of us. The other problem is best illustrated by discussions we had with Jerry Hill when the bill was initially conceived of, which came out of Palo Alto, and I'll talk about that in a minute. And that is that we proposed a real, genuine guarantee, not a guarantee, I'm sorry, a procedure by which the communities could be protected from redoing the system. And that was, we said, you should put in the bill that cannot be changed except by a majority vote in each of the 3 counties in the district. That way, the voters would have the say, and instead they came up with this idea of 9 separate agencies, each of which would have veto power, which sounds good, but if you look at what those agencies are, they're all political organizations, and not necessarily the best sense of the word. They're part of the infrastructure of transportation management. All the money flows through MTC, and what we've learned from experience is those kind of agencies can be very pliable when it comes to receiving funding, so that their position can be influenced by political pressure, arm twisting, and by the distribution of funds. I want to try and wrap up if I can and say that it's a matter of political will whether that will survive or not. They didn't want to have the political will. They wanted the money for the electrification, so they were willing to make a compromise. Political will is a California term. From Chicago, where I'm from, we called it guts. That was lacking, and I urge the council to support the 2 members of your community who are part of the et al. Part of this case, Ted Crocker and Pat Jorney, and file an amicus brief as requested. Thank you very much.
Okay, Ted Crocker, please.
Ted Crocker, 446 Marin Drive. Pat and Charles have touched on most of what I wanted to speak about, so I won't go through it again. Just listening to this, I've been through this with you before when we addressed the amicus brief issue, and I remember thinking at the time, it reminded me of, when I started the watchdog group, and I'd go door to door and talk to people about high-speed rail, and they'd say, oh, yeah, it's a problem, I agree with you, but I don't want to get political. And I felt last time that's what happened with my city. And we have to remember where we were back then. It was, as I recall, Burlingame was trying really to influence San Mateo at that time, trying to get them on board and regards to other decisions. Burlingame did not want to be associated, was worried about being associated with Atherton. I think a lot's changed since that time. I think, we've had the Prop 1A outcome. We've had the Central Valley get involved. The city has put forth $5,000 towards TOS lawsuit. We now see where the Attorney General stands on CEQA, and I don't know how you can, in good conscience, not want to send a message to not only the Attorney General but also the judge involved in these various lawsuits, Judge Kenney. So I guess my concern now, I think this council before me knows all the issues regarding this, knows all the nuances on this case, and that's going to change. We're going to have a change of the guard soon, and we may lose a bit of this knowledge base here, and I think this is sort of a last chance to sort of send a good, strong message. So thank you. And thank you, Mayor, for putting this on the agenda. I appreciate it.
Russ.
Yes, Madam Mayor, I too want to thank you for putting this on the agenda in a public way. I think we have to separate the two issues. We have high-speed rail and we have CEQA. This is really a CEQA issue. And when we talk about sending a strong message, we have to think about that. We have to say this is really the dismantling of CEQA. We can't let that happen. That is probably the strongest authoritative legislation that's ever come before the state of California, and the federal government is saying, doesn't matter. We're going to build whatever we want to build, and it doesn't matter. It does matter. And you have to send that signal to them to say, we believe it matters. This is exactly the kind of project that CEQA protects us from. And if we don't send that signal, then they don't think we care. And we do care. I know you guys care. And we do too. So I hope that you do have the political will to join in the amicus brief. I want to add one thing that Kathleen Kane said about bringing something to the table. Perhaps what we can bring to the table is the fact that this perhaps sets a precedent. And if it does set a precedent, then we're talking about Caltrain electrification as well. And that's something that's very, very local and that we can bring to the table to say, this is not high-speed rail, this is high-speed rail plus Caltrain electrification plus whatever else comes along as far as large public works projects go in the city of Burlingame. Thank you.
Jennifer.
Jennifer Foff, Burlingame. They pretty much said it. I just want to really thank you for bringing this out in the public. I mean, I'm so glad people had something to contribute, and really appreciate it that we get to all talk about it and hear what you have to say. Thanks.
Is there anyone else in the audience who would like to speak in regard to this issue? Okay, I will close the public hearing. Colleagues, I'm sure there's some discussion. Who would like to start?
Can we ask questions?
Sure.
First, as staff, I was going to ask our city attorney if you could comment, first of all, on the chances of our being allowed to join the amicus brief based on your calculations of what we have uniquely to offer.
It's difficult to predict how a court will choose to exercise its discretion. Some are more liberal in granting amicus participation than others. In this particular case, the town of Atherton is quite similarly situated to us in the physical characteristics of where the right-of-way runs, in that it does bisect their residential district. There are houses whose backyards abut the Caltrain right-of-way. So some of the arguments that we would make in terms of being uniquely situated in that regard are quite similar to the town of Atherton's. We do not bring unique expertise as to the question of preemption necessarily. That's not to say that we can't make arguments in an application or that we wouldn't if it's so ordered by the council. I would have to say that all things being equal, it's an uphill battle for the city to be allowed to participate just because of the way that we're situated, but that does not negate the decision to want to try anyway.
I had one other question, and that is, can you explain exactly what Jerry Hill's Senate bill offers as far as protection, and also what other protections we have in place because of the 9-agency memo of understanding? Yes. So the Senate Bill 557 highlights a 2-track system and requires the 9 MOU parties to approve modification to that. However, as the public speakers have stated, the implementation of that in the details and some flexibility written into the legislation, that's the overall goal, although whether it's achieved in reality in the out years or may be subject to amendment, we can't predict with accuracy about that. And because it is the same enactment that the legislation made, they can also amend. The other issue there is that to the degree that this is a question of federal preemption of state law, Senate Bill 557 is state law. So if, many of the same arguments could be made as to that. The
JPB CHSRA agreements, which are unfortunately acronym heavy, are the local agency MOUs, agreements among the agencies. That has a somewhat different character insofar as that sounds in contract rather than legislation, and contract is enforceable under its own terms. So to the degree that those agreements, particularly the latest entered one, the early investment 9-party MOU notes the requirement of both CEQA and NEPA review, quote, as appropriate. And it does include specific language requiring recirculation of the Caltrain electrification final EIR. So there's a specific provision in that MOU which addresses the question of CEQA application. And to the degree that that sounds in contract, then the Surface Transportation Board's assertion of federal jurisdiction doesn't negate the contract terms.
So we do have the protection of the MOU, which, as I understand it, all 9 agencies would have to agree to any amendments to that agreement in order to change it. Is that correct?
So the MOU is subject to amendment or enforcement discretion the same way that other agreements would be. So it's correct that there are mechanisms for amending that would require approval of the signatory agencies.
Okay.
Any other questions? Vice Mayor Brownrigg?
I have a question, yes, and then later on a comment. But the question is, I just want to be clear, in amicus curiae, I think I've sometimes heard the phrase join the litigation, but in fact, we're not joining the litigation. We don't become a party. Am I correct about that?
That's right.
We're merely offering our point of view, our expert point of view on whatever the matter might be.
Right.
So while it could be helpful to the case, I just want to be clear to anybody who's not as in tune with the nuances that we're not actually discussing or becoming party to the actual lawsuit. In fact, that's not possible.
That's right.
Okay, thank you.
It's solely to offer the court a perspective that may not otherwise be reflected by the parties.
My question is, what is the financial impact to Burlingame?
Of participating?
Yes.
Thus far, it's been staff time and reproduction and courier services. It's de minimis cost.
Okay, thank you. Councilmember Deal.
Are we doing just questions or are we doing comments right now?
Well, I'd like to start out with questions, and then that can lead to discussion.
Okay, no questions.
Okay, now we can go into comments. I'll let you start.
That was quick. Let's see. A lot of things have been said about this MOU, and as a member of the Joint Powers Board, I did sign on to the MOU as a representative for Central County, of which Burlingame is a member of the Central County. And when I signed that, the MOU does state that that the tracks will be primarily 2 tracks. There was a reason for that. There are already places where there are 3, 4, and 5 sets of tracks. If they had it written explicitly, it'll be 2 tracks only, they would have to take out all the other tracks that are on the system. That's not going to happen. 4 tracks is not going to happen either. It's not in the blended system. It is not in there. It doesn't matter what the High-Speed Rail Authority says, because the JPA, Joint Powers Board, owns the right-of-way, not high-speed rail. And they've been very forward at the board level and at the staff level of the Joint Powers Board that Caltrain owns the right-of-way, not high-speed rail. So they're going to do what's in the best interest of the Bay Area, not what's in the best interest of high-speed rail. It's true they partner with them for electrification, and for a lot of reasons I went along with that. The passing tracks are part of the blended system also. It's in there. It says they're going to be passing tracks. They've already talked about it. Now, exactly where they're going to be hasn't been spelled out. They're not going to be in Burlingame. We know that. They're going to be farther south. Aerial tracks, there's not going to be any aerial tracks. There's no money for that. There's no money to even build high-speed rail, let alone build some aerial tracks for them. The gate downtime studies that they've done, taking into account 6 trains each direction per hour, in the commute times, and also 2 high-speed rail trains each way per hour in the commute times, show that on most of our gates, there's going to be some gate downtime increases. From what I saw, they weren't dramatic. I have questioned some of the figures that they've brought forward, as saying, for instance, that let's just take Broadway, that there will be a substantial saving in time as the 2 trains pass directly at the same time at Broadway and go past. And I've already brought that up. That's never going to happen, like you said. So these figures may not be exactly right. Now, what will happen with this amicus brief? Will this send a message to Judge Kenney? No, not in any way possible. I mean, I think you're losing what an amicus brief is. It's not a popularity contest. They're not going to say, oh my gosh, Burlingame has signed on, Judge Kenney's quaking in his shoes now. Whether we sign on or don't sign on, the amicus brief is being filed, the appeal is there. It's going to be determined by that, not by whether if 20 cities went on, and in this case, or if Burlingame went on. So I think we're just doing it because we don't like high-speed rail. And if that's the point, it's great. That's okay. That's what you're allowed to say. That you don't like high-speed rail, we'll do anything to stop it. I think it may stop itself eventually because of the lack of money, but that's a moot point. And Russ, you brought it up. Yeah, this is about CEQA. That's the issue that we're talking about, CEQA, not all this other stuff that was brought up. But is Judge Kenney going to make his decision based on what Burlingame says? No. As our city attorney has told us, Atherton has already filed, or is part of the appeal. We're not much different than Atherton. The arguments that they've got have already been made. For us to take the same argument doesn't add any weight to the decision. So I myself am not in favor of just spending our staff time for wasted effort. If we wanted to make a statement against high-speed rail, we could just sign a letter and pass it off, or we could just say a vote that we're opposed to high-speed rail as such. I think the CEQA matter is an issue. I'm not debating that, but it's also in the MOU that they're going to use CEQA. So once again, as the city attorney said, this is contract law, and I may have used that wrong term. It's not. Is it contract law, or is it? Yeah. Okay, I got it right. Okay, that's not going to change. So I just feel it's a false effort to go forward and to be a part of this. So I'm not going to be voting in favor of it unless I get talked into it. You never know.
Councilmember Baylock.
Thank you, Madam Mayor. I want to start, first of all, with the first promise that was made in Proposition 1A when the voters voted on it, that they would honor environmental law. We've had 5 long years in between. The High-Speed Rail Authority has demonstrated time and again that they are bad actors. They do not act in good faith. Caltrain has a sterling reputation with us, and somehow we forget that high-speed rail is not interested in what the voters want. They have tried time and again to circumvent that, and this is the latest maneuver to flout what the voters voted on. Again, and different lawsuits have pointed out different things. The voters had specific things laid out in 1A. This is check in the box. Well, this one doesn't matter either. And CEQA really matters. And why it really matters is not only was there a voter promise, we know the reason California passed the California Environmental Quality Act in the beginning. NEPA already existed under the National Act. California in 1969 did not think NEPA went far enough, the National Act, and passed CEQA. So since 1969, this state has operated under that process, and it's a very good process. It's not perfect, but it's important. The problem is not Caltrain electrification. It's what's been known as Phase 2 of the project. Phase 2 of the project is laid out in the program level EIR as part of the entire program because another promise to the voters was that, one, the trains would travel from Los Angeles to San Francisco in 2 hours and 40 minutes. They would travel from San Jose to San Francisco in 30. That is laid out in the verbiage of the proposition. So tell me how, on the existing blended system of Caltrain, that they're going to meet that 30 minutes. To meet that 30 minutes, they're going to have to do something beyond Caltrain electrification. They've already, in their MOU with Caltrain and the 9 agencies, indicated that Caltrain would be the lead agency for electrifications. Any further environmental documents, Phase 2, would be run by the High-Speed Rail Authority, which we've learned continues to be a bad actor. And again, asking the Attorney General to now throw out CEQA. They continue to earn my disdain. So, Phase 2 high-speed rail, subject to CEQA, that's gone, and it's going to be gone for Phase 2. And we do have to worry about that in our future, because owning property in Burlingame will continue to be affected by the shadow of a Phase 2 project coming through here with no CEQA protection. So the attorney has given us a challenge to show that we are somehow differently situated than Atherton. We may look like Atherton in some ways, but I can give you, just sitting here, 6 things along our right-of-way that are uniquely different. One, we have 2 National Register properties along the Caltrain line, both the Burlingame Avenue station and the Broadway station. Atherton has no National Register properties. We have 25% of our population that lives on the east side. That's not true of Atherton. We had, in the original EIR that they were working on for our segment, identified nearly 100 sensitive receptors within a quarter mile of our Caltrain line. Sensitive receptors being schools, parks, senior citizen homes, historic resources, and others, the high school. So all of this, Atherton has a residential section affected by it, but none of those institutions exist along their right-of-way. We have a protected eucalyptus grove that was deeded to the city over 100 years ago, with the end of the deed requiring that if any of the trees are damaged or removed, that the property, which is owned by the city of Burlingame, reverts to the original owners of the property. Atherton does not have that sort of deed recorded. And it was the first president of Pacific Telco that actually deeded the property, Mr. Scott. So we have 2 downtown districts. Atherton does not. Both of our downtown districts will be adversely affected by a Phase 2 project coming through here on elevated rail. And lastly, we have 6 grade crossings where Atherton does not. So I don't know if that rises to the level with Judge Kenney of being uniquely situated, but that's just sitting here jotting things down. What I've thought of how Burlingame is different than Atherton. So I don't like when promises are broken, and this is a really big one to break to the voters, to all of us. And Judge Kenney, it will be on, the onus is on him whether to decide whether we are uniquely situated enough to join the lawsuit. But for 5 years, the city has worked very hard to protect itself from this project, and I do commend Senator Hill for what he's done to help. But we don't know who will be sitting up here. We don't know who will be sitting in Sacramento or on the Joint Powers Board when Phase 2 comes through. And if we don't make sure that CEQA stands in this case, we have no guarantees at that point. Politicians change, bureaucrats change. So on that note, I will listen to the rest of my colleagues up here.
Councilmember Nagel.
Thank you, Madam Mayor. So the decision before us tonight is whether to join the amicus brief in the case of the town of Atherton versus high-speed rail. And why is that a good idea? Well, you've heard people state that it's important to register our opposition to the argument by the State Attorney General that CEQA would be preempted by the NEPA, the National Federal Process for Environmental Review. The other underlying argument, which my colleague has just articulated, is a desire to really tell high-speed rail that they have done us wrong, that they are the bad guys. And I hope we can separate emotion out of this discussion and just deal with the legal case in front of us. Our attorney has told us that participating in this, we would have a very small chance of even being allowed to join. It would be a true uphill battle, is what she told us, because our interests are essentially the same as Atherton's. And she's told us that our participation will make absolutely no difference in the arguments, the legal outcome, because everything is pretty well represented already. The other thing that strikes me is that if this is really about CEQA, we already have the protections in place for this first phase of high-speed rail. I won't go into detail again, but basically it's the 9-party memo of understanding. And also Jerry Hill's bill does restrict it to primarily the 2 tracks, and that was a huge win to get that signed by the governor. We also are the lead agency in the planning of phase 1 of high-speed rail, and nothing can be done to change that because it's a contract that has been agreed to by those parties. This also guarantees the same MOU, the recirculation of the Caltrain electrification EIR. So we are covered for the first phase of high-speed rail. Now, our city officially has taken a position of favoring the blended system, which is essentially what is before us with electrification now. And this, to put a blockade in the way of this electrification process, in my mind, would be really a bad decision for our city, because it is in our self-interest to have electrification take place. We would have faster, safer, and greener trains. We would get our Broadway service back. And, you know, I am for better transportation. I think we can all agree that the second phase of HSR makes no sense whatsoever. The financial plan, the business plan is absolutely faulty, and there is no money, not a dime, that has been funded for phase 2. We are only talking about phase 1 here. So I think it makes sense to think not of, you know, the political decision of, boy, wouldn't it be nice to really sock it to that high-speed rail authority and join this case, because it makes us feel good because they've been so mean to us and they've ignored us all these years. I think rationally it does not make sense to spend our staff time not only in trying to join the brief, but possibly in court and putting other high-priority city projects on the back burner. We also are not in the position to articulate a different position. And another important consideration is that we would basically end our ability to come to agreement with our neighboring systems on a plan for the future of transportation going through our cities. If we set ourselves up with the Athertons of the world, I think we are saying that we do not want to collaborate. In fact, I have heard that from some of the council members in neighboring cities, that they don't feel that there is any desire to collaborate when we do things like fund lawsuits. So to me, realistically, it doesn't make sense to put a roadblock in the way of phase 1, which we have everything to gain for. We have electrification will make a huge difference. I take the train. I stand on the train a lot already, and I don't think that we have any other way of funding electrification. And when it comes to phase 2, I have no doubt that all of us will do everything possible to make sure that that does not damage Burlingame. If we work with other cities, we can get that track underground, and we can even use the space on top of it for things like public open spaces. So I will not be voting in support of the motion tonight.
Vice Mayor Brownrigg.
Well, it looks like you're going to get 5 speeches, I guess. First of all, I want to thank Charles Volz for bringing this to the council's attention about a month ago. I agree with Mr. Cohen and I think probably everyone up here that the issue between CEQA and NEPA is a really vital public policy issue. I served in the federal government, and I have a very low sense of my own probability that if the federal government is asserting preemption, that the state will prevail. So I start with a view that preemption is a very powerful argument, and when the federal government makes it, it's very difficult to overcome it. That said, I wanted to listen to the arguments for and against an amicus. So for the insiders in the room, I personally draw a pretty big distinction between the Atherton lawsuit and the TOS lawsuit. To me, it always seemed that the Atherton lawsuit, which was focused on environmental issues, would be quite happy to see high-speed rail go up the East Bay and come over the Dumbarton, merge at Redwood City, and keep going to San Francisco. Great for Atherton, not so good for Burlingame. And that's one reason why, for the last several years, I've frankly been reluctant to be very engaged in the Atherton lawsuit. Not that there weren't underlying issues that were meritorious, but that from a rather crass Burlingame point of view, it wasn't the best argument for us. On the other hand, I felt very different about TOS, because TOS says, you guys are not playing by the rules that you promised the voters. And here are all the ways that you're not playing by the rules. And you're not allowed to change the rules on a $10 billion program just because they're inconvenient. And this council supported that unanimously, I think. But certainly we supported funding that very important, principled argument. And I stand by that decision. I think that's the right decision. And many of you know my own feelings about the project as a whole from a financial point of view. All of that said, I don't hear, first of all, it's extremely difficult for the city of Burlingame to draft an amicus. I think we can all acknowledge that it doesn't serve our city to put a shoddy piece of work into the court system, whether it's accepted or not. It reflects badly on us now, and it would reflect badly on us in the future. So we were almost required to join somebody else's amicus if we were going to do this in the time available to us. And the amicus just arrived an hour and a half ago, and it's 60 pages. So it's very difficult for this council, even if we wanted to read the amicus and feel good about it. And then it turns out, not surprisingly, that the amicus, which is drafted by Central County or Kings County, is very Kings County oriented. Makes sense. That's their point of view. It affects them. But they're not our issues. Councilwoman Baylock raises some very good issues. They're not in that brief. And so I don't want to be the Berkeley of the peninsula passing resolutions on nuclear arms. I don't think that's helpful. I don't think it's interesting. And so at the end of the day, I don't think we have a point of view that we can make in this lawsuit with respect to an amicus. However, and I realize this is a distant second best, I would be very happy to see this council draft a resolution saying that we believe CEQA should take, that high-speed rail should be subject to CEQA, not NEPA, and that using NEPA as a standard for high-speed rail now or Caltrain in the future would be deeply detrimental to our interests. And at least then we have the honesty of saying our position, our reasons. We don't try to join an amicus process that I think is very low probability of succeeding anyway. I realize it doesn't do anything from the legal point of view, and Judge Kenney certainly doesn't have to read it. But I think that's the Burlingame position, that CEQA should trump NEPA in this case, that's very important to us now and in the future. And I believe that. I just don't believe the amicus process is the right one, having listened to all of the back and forth. And I'm sorry, I know that disappoints people.
Okay. I'm not sure if I have much to add because both sides have been represented. But I will say that I think the whole process of high-speed rail has been somewhat a disappointing one. And there's been so many twists and turns, and I will give credit to this council for really trying to voice the opinions that we feel represent the city of Burlingame for the past 4 to 5 years. From what the attorney has stated it does sound that we don't really have a good chance of succeeding for a variety of reasons, and that what Atherton is bringing up would be very similar to what Burlingame is bringing up. But I do think this evening Councilmember Baylock brought up some good, unique circumstances that differentiates Atherton and Burlingame. And that is one of the criteria. And I think there could be the possibility of fulfilling that criteria. And even if it's a slim one, my decision is based more on a philosophical reasoning. And one, I do think Burlingame is unique. And secondly, I have a big issue with the CEQA. That, yes, I bet we never thought the federal government would want to do away with CEQA on a major project the caliber of high-speed rail. But it is now happening. Granted, there is an MOU with 9 people that have signed it, that you would need all 9 to agree in order to have CEQA eliminated. But there could be that very slim percentage that 9 people could change their mind and say, let's go a smoother route and go with NEPA. I may know walking into this decision we may lose, but I can't walk away with a good conscience of not joining. And so based on that, and really basing a decision too on, I think Councilmember Baylock brings up a good argument in regards to how Burlingame is unique. And because of my strong support of CEQA, I will support the participation with the town of Atherton with the amicus brief. So on that note, I think everyone has given their opinion, and we're ready to have someone make a motion.
So I'd like to make a motion that the City of Burlingame join the amicus brief with Atherton et al.
And I'll second it. Those in favor?
Can I make a comment on the motion?
Sure.
Of course, I won't be shining onto that, but I agree with Vice Mayor Brownrigg that I would be willing to sign a resolution stating that we want the CEQA process to be involved in both electrification and with high-speed rail coming into the Bay Area, which I think accomplishes the same goal without going into what I think is an unnecessary legal maneuver. That I think when you do too many unnecessary legal maneuvers, it doesn't make you look good at all. And I think that's why Atherton, in my eyes, looks poorly, because their goal is to eliminate high-speed rail, and they will come up with anything that they can think of. So those are my comments.
I do want to mention, I know you're pointing out Atherton because you feel that they are totally against high-speed rail. I just want to mention, just for the record, that I have never said I am completely against high-speed rail. I think high-speed rail can be beneficial. However, I have always been persistent in saying that I'd like to see it underground. Also, we have worked with cities for many years, trying to get cities on the same page as Burlingame, and it's been extremely difficult, to do so. And so I'm not sure if this would even change that momentum whatsoever. All right, we have a motion on the table, and so let's vote on that motion, and we can have another discussion if someone wants to bring up the resolution. Those in favor of the motion?
Aye.
Aye. Those opposed?
No.
No.
Motion fails. Vice Mayor Brownrigg, did you want to bring?
I'll go ahead and, or I don't know, do we need a counter motion or not? Is that action taken?
That's sufficient direction on the amicus issue, and if the council wants to bring back a reso for approval, that's something that you can request at this point.